Child custody. What you need to know. Dustin McCrary, divorce attorney and founder of the law firm of Dustin McCrary, discusses one of the most important issues for most families in a divorce: child custody. Hi, I'm Dustin McCrary, and I'm glad you've joined me today. Today, I'd like to talk about one of the most important issues for many families as they navigate the divorce process: child custody. After all, for most parents, there's nothing more important than the children they love, and making sure that the best child custody arrangement is reached is at the forefront of their minds. First things first, while this video and the other resources on this site are helpful, they're absolutely no substitute for the advice of an attorney who knows and understands the law. That's just the reality of the situation, and it would be a mistake to think otherwise. When it comes to something as important as your children, you want to make sure that you leave no stone unturned and cover all your legal bases. There's simply too much at stake. With that said, it's my hope that the resources on this site are helpful to you as you prepare to address this very important issue, and that they give you some peace of mind as you begin to understand more about the process. In North Carolina, child custody has two main components: physical custody and legal custody. Physical custody refers to where the children actually live, their physical location. Legal custody, on the other hand, concerns which parent will make the major decision regarding the children's lives. Decisions about things like school, extracurricular activities, medical care, religion, and other important matters. In the majority of cases today, parents end up sharing joint legal custody of their children. This may mean that a parenting arrangement specifies one particular primary residence and a primary physical custodian for the children, although joint decision-making is shared by the parties on important matters. It should be noted that even if one parent is the primary physical custodian, this does not mean that the child resides with that parent all the time. For example, if one parent had the children during the weekdays, while the other parent had them on the weekends, the parent who had them on the weekdays, by virtue of spending the majority of the time with the children, would likely be named the primary physical custodian, even though the child spent time each week in both homes. Sometimes partners do enter into a joint physical custody agreement, where the children essentially spend equal time at each residence. This might mean a week on, week off rotating schedule, or it might mean 1 month at one parent's home and the next month at another parent's home. There are really a wide variety of ways to arrange custody depending on your lifestyle. In increasingly rare circumstances, sole custody is still an option for some families as well. In this situation, only one parent is granted custody of the child from both the physical and legal standpoint. In a sole custody arrangement, the parent who is the sole custodian has the responsibility for meeting all of the child's physical needs, as well as for making all of their important decisions on their behalf. One parent may have visitation with the child, but in a sole custodian situation, the child typically does not stay at the other parent's home. This may happen in a situation where abuse existed, or where one parent struggles with addiction or mental illness and is simply unable to care for the children as needed. Now that you understand the basic types of custody, it's important to understand that in any divorce case, regardless of circumstances, a child custody dispute will be resolved in one of two ways, either by the agreement of the parents or by the court. Let's discuss the former option first: settling your custody dispute by agreement. If you ask most attorneys and most people who have been through a divorce, the majority will tell you that, if possible, settling your custody issues and all the other issues that you confront in a divorce is the way to go. It's also the most popular way to resolve issues, primarily because in the long run, it's far less stressful, less costly, less time-consuming, and it gives the parties the freedom to decide their issues in a way that best suits their needs and their lifestyle. It's absolutely the choice to make if it's realistic in your situation. I could spend plenty of time discussing the more technical aspects of creating a parenting agreement, what issues you'll want to cover, and what details you should include, but in truth, that's a matter best discussed with your attorney. After all, much of any agreement if it's truly to be successful, will be tailored to your personal circumstances. Instead, what I'd like to discuss is why parenting agreements are such a good idea and preferable to taking your case to court if at all possible. Obviously, the best advantage of a parenting agreement is the freedom and flexibility that it offers to the parties. When you enter into your own agreement about custody or any other issue, you have the freedom to choose any arrangement that best suits your needs as a family. It doesn't matter if the custody arrangement you decide upon is a more traditional arrangement or if it's extremely unique. It's truly up to you. When you take a matter to court, however, you necessarily give up that freedom. You leave the matter up to a judge to decide. And even though he or she may truly have the best of intentions, the truth of the matter is that no judge is going to know your family the way that you do. Another advantage of entering into your own parenting agreement is that not only do you have the freedom to create the agreement in the manner that you see fit, you and your ex-spouse will also later have the opportunity to modify it if necessary. When you enter into a court-ordered custody arrangement, because the court is the entity that issued the order, it's also the only entity that can later go back and change the order. As you might imagine, it can be stressful and expensive to have to return to court to make changes, and one thing that's true about life with children is that circumstances often change. As your children grow and mature, their schedules will change, their interests will change, and their needs will change. This is not to mention the fact that your lives may change as well. One or both of you may take new jobs. You may begin new relationships. You may have to relocate for one reason or another. When this happens, it's much more ideal to be able to modify the agreement on your own as opposed to having to return to court. On that note, it's important to realize that sometimes, for whatever reason, even parents who initially entered into a parenting agreement successfully may later find themselves unable to come to an agreement as to how to modify it. If this is the case, you will eventually need to involve a court in the matter, and you'll do this by filing what is essentially a new custody action. In that case, the court will review evidence and testimony as if it were hearing the case for the first time, because, of course, it is. As we're getting ready to discuss, battling a custody issue out before the court can be time-consuming and expensive. So it's always best to try to reach an agreement with your spouse on modification instead, if possible. As I've said, sometimes even couples with the best of intentions who love their children very much are unable to come to an agreement regarding custody for one reason or another. When that's the case, it will become necessary to involve the court. If you find yourself in this situation, realize at the outset that it will likely be a fairly stressful process, even in the best of circumstances. Going to court is costly and time-consuming, and things rarely happen quickly. It will also mean that your private life and your personal issues, as well as your parenting choices, will be publicly on display in a courtroom, which is a prospect that many people would like to avoid. In addition, in some circumstances, depending upon the age of your children, the court will want to interview your children as to their preferences about which parent they want to live with. And this can also be stressful and emotionally difficult for everyone. Regardless, if you decide that this is the best way forward for your family, you'll need to file with the court and serve your spouse with the necessary paperwork. After your spouse has filed an answer, your case can begin to move forward. Prior to actually beginning to hear a case, North Carolina courts will require the parties to attend mediation and attempt to work out their issues. Parenting classes may also be ordered, depending upon the circumstances. If neither of these alternative methods of resolution are successful, then the court will officially take evidence and testimony and hear the case. When deciding custody issues, a court will seek to make decisions using the best interest of the child standard. There are a number of factors that courts can consider in making this determination, including issues of morality. For example, whether or not one parent has engaged in marital misconduct, like an affair, domestic abuse, addictive behavior, and the like. The wishes of the children, the involvement of the parents in the children's lives, the home environment that each parent may offer to the child, the capacity of each parent to be a nurturing caretaker to the child, and more. As courts seek to make this determination, They'll review evidence and testimony presented by the parties, in addition to taking the preferences of the children into account if they're old enough to rationally express those preferences. Depending upon the particular circumstances of the case, courts might also appoint a guardian ad litem to represent the interests of the children. These individuals are typically attorneys who are directed by the court to investigate issues of custody and present testimony as to their findings. Often they're only appointed if there's some danger that the court believes the children may face and that they need their own representation as a result. It's nevertheless important to be aware that this is a possibility. After hearing all the evidence presented by the parties, the court will ultimately issue a custody order which sets forth its findings of fact and conclusions of law and specifies its directive as to the custody arrangement that it believes will be in the best interest of the children. It's important to realize that once a court enters this order, it is binding upon the parties and they are legally required to follow it until such time as it is later modified, if that's ever the case. If you find yourself in court over a custody dispute, there are a few things that are essential to keep in mind. Beyond the legal technicalities, there are some simple common sense steps you can take to increase your chances that a judge will view your case in a more positive light. What it really comes down to is putting your best foot forward. Present yourself in the most positive light possible. Most judges handle many custody disputes each year. They hear plenty of tedious details about children's day-to-day schedules and routines. While these things are important, it's also important, if possible, to give yourself a chance to show the court who you really are. Don't be afraid to show emotion and to present evidence and testimony that really shows your love for your children and your relationship with them. While it may be difficult to talk about emotional matters, in these cases, it's important that you wear your heart on your sleeve, so to speak. Be genuine. Be honest. After all, judges are people too. Parents who share their sincere love of their children and their investment in their children's lives are going to have more of an impact when presenting their case. That's simply the reality of the situation. Also, don't hesitate to gather testimony and evidence from other people who have seen how much you love your children and the time that you invest in them. Maybe it's a coach who sees you bringing your children to practice every week or showing up at every game. Maybe it's a teacher who you've corresponded with regularly about your child's progress in school and how you can help him or her to succeed. Maybe it's a doctor or a nurse who testifies that when your child is sick, you regularly take time away from work to bring them to the doctor and to care for them. Maybe it's a daycare worker who can testify that when you show up to daycare at the end of the workday, your child is always delighted to see you. Whatever the testimony is that you think will really make your parenting relationship come alive for the court, you should present it. Lastly, whenever you're before a court, be respectful. Dress presentably, show up on time, do what's asked, don't stall unnecessarily, or use underhanded tactics, or try to get revenge on your ex-spouse simply because you're angry about what happened between the two of you. In the end, you only harm yourself by doing so. In closing, while I've given you a brief overview of child custody law today, I want to remind you again that it's no substitute for the advice and assistance of an attorney who can apply the law to your personal circumstances. Child custody is far too important of an issue to try and go it alone. The resources on this site can be helpful, but they're intended only as a helpful supplement to representation by a knowledgeable and experienced attorney. If you need assistance with your child custody issues or any other issues during the divorce process, I'm here for you. I'm Dustin McCrary. Thanks for joining me today.